Good morning, everyone. My name is Mike Delaney, and welcome to today's webinar, which is to provide recruitment businesses, and I know there are many of you listening, and those involved in direct recruitment with some up-to-date issues based upon questions that have been troubling some of our clients, certainly over recent months, particularly, again, since leaving the EU at the beginning of the year. And today's session does have an international flavour about it. Firstly, we have tbrettyoung, who's a partner here in the immigration team and also in the employment team. He'll be looking at immigration issues arising from the immigration regime, which is affecting businesses, whether you're recruiting directly or whether indeed you're placing candidates who don't have UK passports or indeed residency rights. And following will be Bygrave, who's an associate in our commercial team, and she'll be looking at some of the thorny issues, again, arising from data protection, again, involving international data transfers, and also some proposed reforms that are in the pipeline. And to finish, Zara Gullimsane, a solicitor in the employment team, will also be looking at some of the issues involving IR35, arising again where one of the parties is contracting and possibly or based outside of the UK. But again, before we start, hot off the press, for those involved in recruitment, will no doubt be aware that there is a government consultation on umbrella companies. And the government is essentially going to consult with workers who use umbrella companies. And also this will be of relevance to employment businesses who place temps. And again, there is an intention, if you look at the consultation, that government is hinted that they'll be introducing primary legislation to deal with umbrella companies going forward. So watch this space, and we'll continue to monitor events as they happen in the coming months during 2022. So without further ado, I'll hand over to my colleague, Tom, who will now talk about immigration issues. Thank you.
That's great. Thanks very much, Mike. Morning, everybody. Yes, I'm here to talk about what's changed as far as the UK's immigration regime is concerned. Amy, if you could move us on to the next slide. As Mike said, these changes predominantly are flowing from the UK's decision to leave the European Union, the sort of overwhelming majority of the effects of which took effect on the 1st of January this year. So it's almost a year in. And as a result of that, as a result of the end of free movement for EU national workers in the UK, various adjustments have been made to the UK's immigration system, which have kept us fairly occupied over the last year or so. So we're going to look at the main changes to the immigration system, which have been around the skilled worker route, formerly known as Tier 2 General. And that's the immigration category, which is really does the bulk of the heavy lifting as far as skilled worker and employment visas are concerned in the UK. And then I'll touch a little bit on some of the other changes to the immigration system that we've seen as far as visa categories are concerned over the last 18 months or so. I'm going to talk a little bit about right to work checks, because there have been some fairly significant changes around that. Previously, of course, as employers, as recruiters, somebody holding an EU passport didn't have to have anything else in order to work in the UK. That's all changed now. So we'll talk a bit about how that's changed and what additional checks we need to be doing. And then to finish up, we'll look a little bit about what we expect to come over the next year or so. There are some further changes to the immigration system planned, so we'll think a little bit about that. So lots of words on this slide, and I don't propose to go through everything in detail out of kindness to you all, and I suppose to my colleagues as well who are following on after me. as much as anything else. Just to sort of flag really the changes to the immigration system have been in the planning for a sort of year or so before the end of the Brexit transition period, and slowly implemented as we had a bit of a drip feed, as it were, of changes to the immigration system. The significant changes really took place just over a year ago, when a series of rule changes took effect, adjusting primarily existing immigration categories with some changes in terminology, but the overall principles of the immigration system remain the same. But we had sort of a few substantive changes to some of the existing categories, which on the whole have made things easier for employers. Really, I suppose, taking into account the fact that there is now a significant number of people who require immigration permission, whereas previously they didn't. And just to sort of flag, I'm not really going to talk about it to a great extent beyond this slide. So some of those changes have been are not really Brexit related, or not directly Brexit related, more driven by politics, and those have been the last. That's really related to the last point on this slide: the introduction of short-term visas for certain what might be seen as lower skilled workers, so HGV drivers, poultry workers, pork butchers. Although there is some flex in there for some more higher paid roles within those, but those schemes, much publicised, were introduced as a short-term stopgap in response to shortages in specific sectors, complaining of skill shortages, and really only intended as very, very short-term visas, not leading to any longer-term residency rights at all. The main reason for flagging it, I suppose, is that it may be, though, over the next few months, years, we may see further skill shortages in certain sectors. I don't think the government are terribly keen on doing this a great deal in the future. Certainly the noises coming from them is that they were sort of doing this all very reluctantly, and certainly from speaking with contacts who work in some of those sectors, they're not entirely convinced that those temporary visa categories are going to do an awful lot in the medium to long term as far as their recruitment needs are concerned. But it may well be that if there is significant publicity in the future around other skill shortages in certain sectors, we may see other short-term routes introduced. So the main change, as I've said already, is in relation to what we call the skilled worker category. This used to be known as Tier 2 General, and the general principle is that you have an employer who needs to recruit somebody from overseas. That employer needs to hold or apply for and then be granted a sponsor license by the Home Office, and then with that sponsor license they can issue virtual certificates of sponsorship to support the visa applications or permission to stay applications by the skilled workers who they want to sponsor. That was the case under Tier 2 General. That remains the case under this new, I'll say new in inverted commas, skilled worker category, which came into force on the 1st of December last year. So the general principles are the same, but there have been some adjustments to that category. One of the main ones being that the minimum skill level requirement, which under Tier 2 General was RQF level 6, broadly graduate level positions, has been reduced to RQF level 3, which would, I suppose, be seen as somewhere at around A-level type qualifications. That's not to say that you need to hold those qualifications in order to do the job. That's the skills, experience, attributes level that those jobs are assessed to be at, and there is a long, detailed list of occupations which qualify under those skill levels. So, by reducing the skill level requirement, we've greatly broadened the number of occupations which are now capable of being filled by a sponsored worker. Under the Tier 2 general category, there was what we referred to as a resident labour market test. This was effectively an advertising requirement. You had to carry out advertising exercise in a pretty prescriptive, bureaucratic tick box fashion in order to demonstrate that nobody within the UK could do the job. That requirement has been dropped altogether. There is still what they refer to as a genuine vacancy requirement. So if asked, you may need to demonstrate that the job is genuine, and to do that, you can prove that you've advertised or carried out other recruitment type activity in order to demonstrate that that the role is genuine. But you don't have to show that by bringing in a sponsored worker from overseas, you're displacing or that you're not displacing resident labour, for example. The requirements all around the job being genuine, not about whether there is a particular gap in the labour market. Under the Tier 2 general category, we also had a nominal cap on the number of people who could be sponsored under that category every year. There were plenty of carve-outs, and in practice, the cap was rarely ever reached. And in fact, when it was, on the occasions when it was, the government would generally then find some other reason to exempt certain people who were being excluded, or otherwise mitigate against the problems that cap caused. So the cap has been now removed, albeit, as I say, it had very little sort of practical effect in the past. But there is still a mechanism within the skilled worker category for, I suppose, in a way, controlling the people who come from overseas, which is that instead of having a sort of an allocation of certificates that you can draw down from every year, you actually need to request certificates of sponsorship as and when you need them when you're recruiting somebody from overseas. So there still is an additional step to go through where the person you're looking to sponsor is going to be applying from overseas, but it's not. There's no cap involved. There's no restriction on numbers at all. Switching is easier. What do I mean by that? Well, within the immigration rules, the rules which govern who can come to the UK and the conditions which they're bound by, traditionally, historically, there have always been quite tight restrictions on who is allowed to apply from within the UK to change their immigration status. And under Tier 2 General, there was a very sort of tight list of categories which you could switch categories, which meant you were sometimes in a situation where somebody's in the UK filling a role, but instead of being able to apply to extend their stay under the Tier 2 General category, they would actually have to leave the UK and make their visa application from overseas. And under skilled worker, that list of categories which you can switch from is now much longer. So it's much easier to switch your immigration status if you're here in another category at the moment, although important to flag that visitors to the UK still aren't able to switch into the skilled worker category. But many categories that previously weren't able to can. So that is good for the environment, cuts down on air miles, and generally makes things much more straightforward where somebody is in a role and you need to extend their stay under the skilled worker category. The skilled worker category, along with many others, are sort of billed as part of the points-based immigration system. When we look through the rules, there isn't really an awful lot that is points-based about it. Points-based suggests there's some sort of flexibility within the requirements that can be traded off. If you don't score points in one area, you can actually make them up in another, and so there's some sort of flexibility within the category. Actually, there's very little of that within the UK's immigration system, albeit a lot of it is billed as being points based. Where that we see that kick in for the skilled worker category, though, is in relation to the salary requirement. There's a headline minimum salary requirement of 25,600 that can actually be reduced as low as 20,480, provided certain other criteria are satisfied. So if the worker is applying to fill a shortage occupation job, for example, or is a new entrant to the labour market, so they're switching from the student visa, for example, or they're under the age of 26, you can reduce the salary to reflect their reduced experience, I suppose, in those circumstances. So there is a sort of tradable element. And final point, just on this slide, just to sort of flag, is in relation to the what we call the cooling off period. So under Tier 2 General, in addition to often having to go fly home in order to make your visa application, you may also have found yourself in a situation where you couldn't apply again under the Tier 2 General category because you'd spent too long in the UK previously. Cooling off periods are now scrapped. So again, much more flexibility within that. I'm not going to go into this slide in any real detail. This slide really is just there for information, just to flag the additional types of roles which now qualify under the skilled worker category, which previously wouldn't have done, just to highlight that sort of lower half of the table, lower skilled. There are still jobs which don't qualify. So when sponsoring somebody, do always watch out to make sure that the job couldn't better be described as a lower skilled job, and therefore wouldn't qualify. I don't want to ease into my colleagues' time, so I'm not going to go into an awful lot of detail here. Just sort of, again, for information, just to flag, there have been some relatively minor changes to some other categories. We've now got a graduate route, which was introduced in the summer, which allows students to extend their stay in the UK to work without the need for a sponsor. Hong Kong B&O visa for families from Hong Kong who want to relocate to the UK, that was introduced earlier this year and has seen quite a lot of take up. Global talent, I think we've got a couple of people from universities attending this morning, and indeed if you're from a recruitment business and you're working with universities, is a good category for universities, because lots of academics might qualify under the global talent category for experienced and well-regarded workers from various sectors. And then various other sort of tweaks to the immigration system, which I won't go into, but if there are any questions about that, do let me know. So I'll just briefly go over what's changed as far as right to work checks are concerned. So following the Brexit transition, we had a grace period of 6 months when we could continue to accept EU national passports as proof of right to work without anything further than that. 1st of July, that changed. So EU national passports, when you're checking the right to work of new employees, you can't accept an EU national passport or indeed any other documents which were issued under the old EU free movement regulations. Instead, you would need to see some other proof of right to work. For EU nationals who've been in the UK since before the end of the Brexit transition, that would be a digital status proving that they've been granted pre-settled status or settled status. Or it may be, as you can see from that bullet point, an EU settlement scheme certificate of application proving they've made an application under the settlement scheme but haven't yet had a decision. So do make sure that your the list of documents you're relying on when checking the status of new employees has been updated to reflect the changes that took effect on the 1st of July. Interesting that there has been some sort of tweak since the 1st of July in relation to people who've made late applications under the EU settlement scheme. If they produce a certificate of application and you then carry out a check with the employer checking service, that is enough for you to allow them to carry on working, albeit just for a 6-month period while the employer checking service document that they've issued to you remains valid. But again, some things just to watch out for as far as that's concerned. And you may be aware that throughout the pandemic, the process for conducting right to work checks has included this adjusted process where you can check somebody's documents remotely, and the deadline for that was due to expire in the summer. That's actually now continuing to the 5th of April 2022. And what the government have said is that they're looking at ways of adopting a permanent or a way of checking right to work status of British citizens who currently who can be checked remotely under the adjusted process, but when that's not in place, you would actually need to see the individual with their passports in the flesh. So looking at some alternative way of doing that remotely, which hopefully we'll have announced at some point before the spring. I won't go into any detail here. This is just sort of talking about conducting online right to work checks, which is going to be something we're going to have to get used to more and more, because the government's intention is for the immigration system to become, to use their words, digital by default. So in the future, nobody will have a stamp in their passport or a physical residence card. What they will have is a digital status. So under the new right to work guidance, it does talk in a bit more detail about how to conduct right to work checks on people who hold digital status. And as you can see from the slide, quite a few people can already have that status checked digitally. So if it's not something you've done before, I suspect you'll have to do it at some point in the near future, and it will become a greater part of the way in which we conduct right to work checks. And just to flag some things that we're expecting to come up over the next few months, some things which aren't terribly exciting to most people, but quite exciting to me. So we've got a new immigration category coming in the spring, the scale-up visa, and we may have at around the same time reforms to the existing intra-company and global mobility routes. The sponsor management system, for anybody who already is a sponsor and uses the sponsor management system, is currently old and decrepit and an awful bit of technology, and we are promised an upgrade to that at some point next year. Fingers crossed. It's something we've been waiting for quite some time. And the other thing which we may see over the next 12 months, maybe longer, is, as I said already, maybe further sector-specific concessions for lower skilled / lower paid workers, depending on whether they can kick up enough fuss and make the government embarrassed enough that they have to introduce some sort of concession. All right, I think I've eaten into my colleagues' time enough already. So I think, Amy, if you skip on, that's the last of my slides. So I'll hand over to Penny to give you that data protection update.
Thank you, Tom. I'm going to be giving just a brief update on three subjects. First of all, going to be looking at the risk of liability for data breach claims. Secondly, the responsibility for doing data transfer risk assessments. This is particularly relevant, but this is only really relevant if you're working internationally. And then to look at some proposed changes that are coming up and the effect of the DCMS consultation. So first of all, on the risk of liability for data breach claims, the starting point is a big decision. So as lawyers, big decision in Lloyd and Google this year. If you haven't followed this, if you weren't aware of this, Mr. Lloyd made a claim against Google going back to 2012, so it's under the 1998 Act, although all the principles are the same for GDPR. And he claimed that Google had misused his information when they introduced a particular some technology on the iPhone. I'm not going to go into the technical details of it, but basically the claim was that Google had misused his information. So 2 points that had to be considered. First of all, under the Data Protection Act 1998, let's say probably similar considerations for GDPR, could an individual claim damages for loss of control? And then secondly, the case was considering whether or not one person could make a representative action, and then if they were successful, then everybody else affected could make the same claim. Now, this is really important because for organisations that experience a data breach or do something that's relatively minor, you could actually have hundreds, thousands, and in the case of Google, 4 million affected individuals. Now, we're seeing a lot of ambulance chasing type claims recently, where people are making claims for possibly, £500, maybe £1,000, maybe a couple of £1,000 for misuse of personal data, for loss of control arising out of a data breach. So organisations, if this case had gone through, could be facing millions, if not billions of pounds worth of damages claims, just saying, you have my data, you experienced a data breach, pay up, I'm entitled to compensation, simply because that has happened. And data controllers will all be breathing a sigh of relief to know that this decision has made that is not possible. So first of all, the court said that damages, the automatic damages that might be awarded for loss of control are not available for a breach of Data Protection Act. The individuals must show that they have experienced some form of damage or distress. Now, that is not a particularly high threshold. We've seen in other cases, let's say £750 awarded just for their, the messing around that somebody has to deal with having experienced a data breach by a large company. So it doesn't get organisations off the hook, but it means that there's no carte blanche, there's no automatic claim simply because the data breach has happened. The individual must establish what damage or distress they have experienced. And that is why the representative action failed, because whilst it may be possible to establish liability for the actual breach under a representative action, because each individual will have suffered damage or distress differently, there can't be a one action and then allowing everybody else to claim. So on the one hand, we can all sort of breathe a sigh of relief. We're not about to face, millions of claims for £500. But it hasn't gone away. And the main thing that we're seeing, again with this ambulance chasing, to be aware of, is cookies. So the cookies rules changed recently. I don't know if you probably all experienced it. You're being given far more options every time you go on a website to select the cookies that you use. So the rules, technically they were always there, but they have certainly been beefed up. You must tell people if you set cookies, you must give a clear explanation of what cookies you use and why, and you must get the user's consent, and consent must be actively and clearly given. So if you haven't updated your cookies on your notices on your website to comply with the new rules, do so now, because that is now where we're seeing the ambulance chasing. We're getting lots and lots of claims for £500, £750, and generally the distress is, I don't know where my information has gone and I'm concerned about it. Whilst we might argue that for £500 to make somebody go away, it's going to cost you less than instructing lawyers. So these ambulance chasing claims are still out there. Easy way to make that claim is by just going on a website, seeing that they haven't got the correct cookies notice, and then sticking a claim in. And we're seeing a lot of that. And the claims are being made by these lawyers. You can even see in the claim forms that it's being cut and pasted again and again. But that is out there, that is a risk. And the other thing is when you have a data breach, because these days cybersecurity experts are saying, it is a case of when, not if. You have a data breach, there will be a loss of control, and for some people that may result in damage or distress. They will have to establish that themselves, but may face claims for that, and you can, whilst you can't avoid the claim, and you can take steps, but as I say, it is a case of when rather than if. We're all going to experience some form of cyber breach at some point. Have a data breach response plan ready to go. So think about this in advance, and what steps you are going to take when this happens, because whilst you can't stop the inevitable, you can be prepared for it. And if you need any help with that, you know, we're here. We do that work with lots of our clients, you know, to help them. So there's no one size fits all. The Information Commissioner's Office has some good advice on that, but if you want to have a chat, we are also here. So the next thing I wanted to talk about was data transfers, international transfers. Now this has been sort of knocking around for a while since we had what's known as the decision in Schrems 1, Schrems 2, Privacy Shield. Anyone who's attended these webinars before for this sector, I've talked about it before. I'm not proposing to go into the background detail of Schrems. The important thing to know is that if you are working internationally and internationally between the EU, transfers between the EU and the UK, but also transfers between the UK / EU and the rest of the world, there are rules that you need to be aware of. So I'd just like to do a quick poll, just out of interest, to see how many of you are awake and still listening to me, and how many of you are actually involved. So do you operate your business in territories outside the UK and outside the EU? For the time being, we're permitted to transfer within the between the UK and the EU. So really, we're looking at outside, so the US, India, China. If you could answer that. Host and class cannot vote. So I'd be interested to see. Right, so the majority of you here are not. Some of you are. So I'm going to be very brief then on these slides because it's not going to be relevant for most of you. But if you do transfer information internationally, you need to be aware that you need to follow the UK regime. And if you are transferring between the UK and Europe, you need to follow the European regime. They are similar, but not identical. And the main change is that when you're doing a transfer, an international transfer to a restricted country, and at the moment for the UK and the EU, there's no restrictions, but US, China, India, etc. are restrictions. You must carry out an adequacy assessment of the country where you're transferring data to, and you must implement supplementary measures if they are deemed not adequate. Now we know, because it was the substance of the case was around the US, so we know the US is for the most part not adequate, but the adequacy measure, the supplementary measures that you need to take will vary depending on the nature of the data. The UK, the Information Commissioner's Office for the UK has issued some really detailed but very good and pretty clear guidance, a 3-step process that you need to follow to see if you can make the transfers. The European Data Protection Board has also issued guidance, a 6-step process, but it's ultimately the same. It's the same steps, then just different numbering, different criteria as to how to carry out these assessments. We can help. Really, sadly, there is no quick and easy trick to this. You have to look at it each and every time. But again, if you have a risk assessment policy in place, then you can know what questions you need to ask, and you'll just get used to following the process. It is bureaucratic, it is administrative, it makes lots of money for lawyers, it places a burden on businesses. Unfortunately, these are the rules for the time being. because as we go on to my last slide, and the last point I wanted to talk about is just looking to the future. Now, earlier this year, the department, I always love this from the television drama, the Department for Digital, Culture, Media and also Sport. So DCMS, they issued consultation, a very, very wide-reaching consultation. I think we've gone back, oh no, sorry. Yes, we're on the right side, apologies. And to reform the UK data protection regime post-Brexit, to really try and increase our position in the world as being the place to do digital business. So the proposals in the consultation are to reduce the barriers to innovation, and there should not be data protection says no, that if you're trying to come up with new and innovative ideas, it is supposed to be reducing the compliance burdens on business, as my previous slide showed. Those burdens are not reduced if you're working internationally, but that is the purpose of the consultation, to see how that could be reduced. The proposals behind the consultation are to support vibrant competition and innovation to drive economic growth, to maintain high data protection standards without creating unnecessary barriers to responsible data use, to keep pace with rapid innovation of data-intensive technologies, to help innovate businesses of all sizes to use data responsibly, but without undue uncertainty or risk, and that's both in the UK and internationally. And they want to reform the Information Commissioner's Office. Now, broadly speaking, the ICO's response is very positive to the consultation. They also do not want to see data protection as being the barrier to business and innovation. However, the ICO has said that despite broad support for the proposals, there are some important, very specific issues where they have concerned, and that the devil will be in the detail. And unfortunately, we don't have that detail yet. The ICO is very, very concerned about the changes to the regulation, and actually on that point, they've said that the current proposals, they do not believe safeguard the independence of the regulator's office, and they are asking the government to reconsider those proposals. And then the other risk, which the ICO hasn't sort of gone into, because I don't think it's there, it becomes an almost bit of a political comment, is what would this mean for our UK adequacy decision? At the moment, we are able to share the transfer data between the EU and the UK because the EU has decided that the UK data protection regime, it's based on the EU GDPR. It looks very similar. It has the same protections that EU citizens have. If we take those protections away and move too far towards business, prioritizing business rights to use data over individuals' rights to privacy, we are at risk of losing our adequacy decision. Nobody is saying at the moment that that is the case, but as the ICO has pointed out, the devil will be in the detail when we see what the proposals are that are coming in next year. So I'm expecting to see some changes next year. I'm hoping that those will be to reduce some of the compliance burdens. I hope they don't go so far as to reduce the compliance burdens to mean that the UK is no longer adequate to share data with the EU, because that will introduce new burdens. So watch this space. And I hope, and as I say, if you have any questions about international transfers in particular, do get in touch. And on that note, I will hand over to my colleague, Zara.
Thank you, Penny. So as Michael mentioned at the beginning of the webinar, my name is Zahra Ghulam Hussain and I'm a lawyer in the employment team at BWV. So for this section of the webinar, I'll be speaking about the IR35 regulations, also known as off-payroll working regulations. I'll be going through the changes to the regulations since April of this year, and I'll also discuss what happens if there is an overseas element and what constitutes being outside of the UK for the purposes of the regulations. And then lastly, I'll run through a few scenarios where there are certain overseas elements at play. And if we have time at the end, Michael and I will also try and answer your questions regarding IR35. So in terms of background into IR35, Amy, yeah, thank you. Next slide. In terms of background into IR35, as you may be aware, the term IR35 is the name given to the tax legislation called the Income, Earnings and Pensions Act 2003. It applies when an individual, normally a contractor, provides their services through their personal services company to a client where they could be regarded as an employee of that client. Now, a tool which HMRC offers, which could be used to find out if a contractor would attract employee status, is the CES test. However, it's also useful to obtain legal advice to check employment status, as there is an abundance of case law in this respect. So factors used to determine employment status include the right of substitution. So if the contractor, for example, is providing a personal service, or if someone else could step in, or if either party could allocate a substitute, that would affect employment status. Another factor would be integration into the workforce. So if, for example, the contractor would be a part of the company's website, have a company email address, required to wear a uniform if the rest of the company is too, or whether they're using the company's resources or their own tools, that will point to integration into the workforce. And then other factors would include mutuality of obligation between the parties and whether there is a degree of control exercised over the contractor, along with any financial risk to the contractor when running their own business. Now, it's important to note also that HMRC would also look at the reality of the arrangement and not just the contract in place. So, for instance, if the contract includes a right of substitution, if it's unlikely that this right could be exercised in practice, this right could then be questioned, which could affect the employment status of the contractor. Now, from 6th of April this year, the reforms to the IR35 regulations were extended to the private sector and not only public sector clients. The regulations, however, do not apply to small companies as defined in the Companies Act. A small company would be a company meeting 2 or more of the following criteria. So one being an annual turnover of no more than £10.2 million, balance sheet of a total no more than £5.1 million, or no more than 50 employees on average over a year. So in accordance with the new regulations as well, the burden to ensure, and this is very important, is the burden to ensure whether IR35 regulations are complied with have shifted from the worker and their intermediary to the end users. So this would mean that the end user is now responsible for undertaking a status determination statement to determine if the contractors engaged would be deemed employees if they were engaged directly by the end user. So if this contractor is determined to be an employee, the fee payers would need to make deductions of income tax, employer and employee national insurance contributions, and even apprenticeship levies if applicable. So it's useful also to mention that if an agency is involved, then even though the end user would still be responsible for making the status determination statement, the agency, being the fee payer, would have to make the appropriate tax deductions if the contractor was deemed to be an employee, if they were directly engaged by the end user. End users should also ensure that they have a dispute resolution process in place in the event that the contractor wants to challenge the status determination statement. So moving on to the next slide. So the situation gets slightly more complicated when a party is based overseas and is out of the UK jurisdiction. Situations may arise in which either the contractors are providing their services via their personal services companies and are based abroad, or if the services are being provided overseas, or even if the end user is based abroad. So in these scenarios, our clients would question whether IR35 regulations would apply, And if so, who would be responsible for compliance with the IR35 regulations? Now, strictly speaking, for the purposes of the IR35 rules, government guidance has stated that if your organization is based wholly overseas, the off-payroll working rules do not apply. And now an organization is classed as overseas if it does not have a UK connection. And your organization will have a UK connection if the organization is either a resident in the UK or has a permanent establishment in the UK. So for instance, if the individual behind the personal services company concerned is not a resident of the UK, nor does it have a permanent establishment in the UK, then it wouldn't have a UK connection. In the same way, the personal service company should not be registered in the UK in order for it not to have a UK connection. And with regards to the end user, for it not to have a UK connection, it should not be a tax resident in the UK or have a permanent establishment in the UK, such as a branch or office in the UK. So I've added a few scenarios to put this into practice, and it may be helpful if you find yourself in a similar situation. So the next slide details a scenario in which the end user is based in the UK. However, the contractor they're engaging is based overseas along with their the personal services company, and they're not a UK resident. Along with that, the services are also being provided overseas. So in this situation, this wouldn't really result in any UK tax liabilities, as no PAYE or national insurance contributions would apply. So technically, a status determination statement would not need to be carried out. The new regulations do not intend to create additional tax liabilities which wouldn't really exist in the first place. However, some companies may be ultra cautious and choose to carry out a status determination statement, even though on interpretation of the regulations, it may not be required. So in this scenario, you don't really need to carry out an SDS, and then obviously you wouldn't really need to pay the income deductions or any national insurance contributions. However, we have to bear in mind that if there is a possibility that the services may be provided in the UK, even for a short period of time, this could then change things, and this could attract an obligation to undertake a status determination statement. So whilst the contractor is being engaged via their personal services company, you need to be mindful of this factor and be aware that if circumstances change at any point of the engagement, a status determination statement may then be required. In the next slide, I've detailed a scenario in which the end user is based in the UK and the contractor is based overseas, but the services are being provided in the UK. So in this scenario, the end user, obviously not being a small company, would be caught by the IR35 regulations as a contractor's services are being provided in the UK. The end user would then need to make a status determination statement to determine whether the contractor is deemed to be an employee for employment taxes, and subsequently would need to make appropriate deductions for taxes if the regulations applied. Right, so in the next slide, I'm examining a scenario in which the end user, hirer, may be based outside of the UK jurisdiction. So what happens when an overseas end user engages a UK resident worker who provides their services through their UK resident personal service company directly with the personal services company, but some work physically performed in the UK and some done overseas? Now, in this scenario, as the end user is overseas, this would obviously lead to concerns of, firstly, whether the end users based overseas could even be aware of the IR35 regulations in the first place, along with concerns about enforcement of the regulations. Therefore, in this scenario, if the end user is based wholly overseas and is not a resident in the UK, has no establishment in the UK, no branch, nothing of that sort, then the old IR35 regulations may apply, in which it is the contractor's responsibility to undertake a status determination statement. And then they would be able to determine if they would be deemed an employee if engaged directly by the end user. So essentially, compliance with the IR35 regulations passes down the chain to the contractor. And if the status determination statement reflects that they would be an employee, the contractor's personal services company or intermediary would be responsible for making the necessary tax deductions or national insurance contributions. Now, it's really important that I mention that at present, the IR35 regulations appear to be silent with regard to the employment tax treatment of contractors providing their services from outside of the UK. We hope that the position will become clearer early next year when HMRC will potentially challenge any decisions and self-assessment will take place. But however, as the IR35 regulations are still relatively new to the private sector and there is limited information or precedent in relation to the overseas matters, we are yet to ascertain the approach HMRC may take relating to these matters. If we have any further updates, we would be sure to try and provide these in subsequent webinars. But for the moment, this is the position there is. We've interpreted the regulations as much as we can in terms of the overseas element. But in terms of the new regulations, the main aspect to be concerned about is the fact that the end user is now responsible to making status determination statements, and it has now passed on from the contractor to the end user, and the end user has to ensure that they get the relevant advice in terms of whether the contractor via their personal services company would be deemed an employee if they were engaged directly with the end user.
Tom, I think there's a question for you. How long does the skilled visa last for?
Thanks, Mike. The skilled worker visa can last as long as you want it to, in a way. It's as long as, so if you've got a fixed term employment contract, it can't last longer than that. You can grant it have it granted for up to 5 years initially, but you can extend it beyond that if the person doesn't qualify for indefinite leave to remain. I should say as well, once you apply for the visa for longer than 3 years, the fees start doubling. So it does become more expensive the longer you do it. But yeah, how long do you want it to last for is the question.
There's another one, I think, Zara, for you. A contractor question, I think, who supplies through a personal service company services to an end hirer in the British Virgin Islands, and asks how IR35 would apply. I think you've answered that question already. As the end user is outside the UK, that end user wouldn't have to make a status determination statement.
Pass on, to the contractor via the personal service company. They would then need to make the status determination statement, and then also if they are deemed an employee, then the personal services company would have to make the relevant tax deductions and the national insurance contributions. But again, as I say, it's all up in the air at the moment, so we need to obviously bear in mind that in the new year, hopefully we'll get more information, and HMRC will challenge decisions. So we'll find out more about the overseas element and be sure to provide any further information on that.